morning, good evening, and welcome to the Intellectual Property Rights and Agricultural Research for Development webinar. I'm here with representatives from both WIPO Green as well as the Big Data CGIAR platform. Specifically, I'm talking to Dr. Peter Oxen, the Senior Program Officer at WIPO Green, as well as Ms. Anya van der Raap, Senior Program Coordinator at WIPO Green, Mr. Yan Zong, Associate Program Officer at WIPO Green, as well as from the Big Data CGIAR platform, Brian King and Rodrigo Serra. Brian, I'd love to hand it over to you really briefly to start us off for this webinar.
Thanks a lot, Ariana, and thanks for the introduction, and thanks to all of you for joining. Just very briefly, CGIAR, I think comes from a tradition of producing international public goods and being stewards of those goods. And I think is sort of perhaps been perceived as being solely about producing international public goods. But the reality related to intellectual property for CGIAR is significantly more nuanced. And certainly over the last 5 to 7 years, my understanding is this has kind of been built out a bit more. And so CGIAR, as a global consortium of agricultural research institutes, the whole of our strategy is sort of nested within the Sustainable Development Goals. And there are particular outcomes that we're trying to bring into being in the world related to livelihoods, poverty reduction, agricultural productivity, sustainable ecosystem services, and so forth. And so really our intellectual property view flows from those desired outcomes. And there's really a whole spectrum of ways that we can engage with public, private, nonprofit actors around intellectual property of the technologies or recommendations that we produce, the genetic resources that we are stewards of and we seek to kind of use for global food security purposes. And so thanks to Rodrigo Serra and his consulting company, One Planet Solutions, and working in a capacity as well as a consultant for Big Data Platform, he really kind of signaled that there's an opportunity here for working with World Intellectual Property Organization, who themselves, I think, actually have much more nuance in terms of how they handle intellectual property vis-a-vis the outcomes that they would like to bring into the world. And so it's my great pleasure to hand off to Peter, Anya, and Jan to help us understand a bit more about that, and then see how CGIAR and CGIAR Big Data Platform and the World Intellectual Property Organization could collaborate around WIPO Green, which our colleagues will explain to us here briefly. Thank you, or shortly. Mm-hmm.
Thank you, Brian. Yes, so we are very pleased to be here today, and it's the first time that we have this direct cooperation with CGIAR and CIAT and the other organizations. And we see this as a great opportunity to help broaden the understanding of what the IP system is capable of doing and how specifically it might fit into the special situation of public research and public research in agricultural science. So to that end, we have prepared a presentation here, which will last, I hope, less than an hour. And then after that, we are open for questions and further discussion into this topic, which at times can be a little bit complicated, but we are not, of course, in this introduction here going too far into these minor details. So I'll start the presentation here. So, right, so we are, hang on. Oh, now we have to get it up here. Hang on. So we have divided the presentation into 4 parts. One of the first, we'll look into the IPR in more general, the intellectual property rights system in more general, and how it fits into agricultural research for development. We will talk a bit about the IP system and some of the tools and assets that are available in that. And mostly we will be talking about patents, because patents is what is most relevant in the context here. And then we'll talk about technology transfer, and how IP relates to that in relation to agricultural research. And finally, we'll be talking a little bit of where we come from, which is WIPO Green. And besides WIPO Green, we come from a house that's called WIPO, a World Intellectual Property Organization. So we are one of the 15 specialized agencies under the United Nations. And we have around 192 member countries. The purpose of WIPO, which was established in 1967, is to promote innovation and creativity through a balanced and effective international property system. And we do this by administrating 23 different treaties in relation to intellectual property right. One of the major activities we have here in the house is a global registration system for trademarks, industrial designs, and we also have a filing system for patents, and we will get into that a little bit later on. We also have a rather strong capacity development mandate, and there are a lot of online courses available in various areas of intellectual property regimes. So I want to start out with highlighting some of the typical questions that you often are confronted with when you talk about intellectual property issues in relation to an organization like CGIAR and the organizations that it represents. Now, one of the first ones is that's one of the major issues is that you are all public research institutions, and public research institutions are destined for public use. So you can ask a question, so what has intellectual property rights to do with that? And the question there often arises because intellectual property rights are often associated with private companies, with commercialization. But we'll try to show during this presentation that intellectual property rights is not only about privatization, not only about value capture from an innovation, but it's also a matter of basic protection of author rights or innovator rights. And therefore, we believe that it also has relevance for the organizations represented by CGIAR. IP rights may also generate revenue source or revenue that could lead to cost recovery for some of the research programs. It's not always the case, but it may, in some cases, be able to do that. Another argument that you hear sometimes that if you get into this area, then you are starting to blurring the lines between the public and private research. And of course, this is a valid argument. Public research is a public domain, but as I said again, this is not only a matter of commercialization. Related to this is sometimes a perceived fear that this will lead to privatization of public goods, which is again a valid argument, but also, as mentioned before, today, I think the lines between what is private and what is public is sometimes being difficult to distinguish clearly, not least when we have something like public-private partnerships, which I know that many research organizations are increasingly not being forced necessarily, but also often voluntarily can see that has a very good reason for going into. And then finally, that you shouldn't go into generate revenue from public research because the public research has been paid by taxes. That is, that it has already been paid for basically, and therefore the users should not pay it again. It's a kind of double taxing. And again, also a valid argument, but maybe this phrase here is something that members of CGIAR have heard recently. It was from the climate summit here in July, where Bill Gates was praising the work of the CGIAR and at the same time pledged a funding of 310 million over the next 3 years. Meaning again that the double taxing argument may be very valid, but there is also funding coming from outside of public taxes revenues. And therefore, again, there might be also issues to look into IP rights here. Now, why is it relevant in relation to the CGIAR context? Now, we've tried to come up with some very basic, shall we say, arguments for why IP rights may be relevant. And one of them is that that if you want to do technology transfer, then you have a better chance of doing it successfully if your IP rights are relatively clear. And this has to do with many factors that we'll come into later on. But basically, it's a matter of clarifying the rules of the game, so to speak. So you don't go in and innovate something or diffuse a new innovation without having unclear ideas of who exactly, where does it come from, who exactly has the rights to this. Talking of these public-private partnerships, it may actually be a prerequisite that the intellectual property rights have been clarified for private companies to be able to go in and do it. And this has to do with that it's easier to invest in something if you know that it's clear who is the owner. So basically, when you start doing work like that, also when you start doing research corporations, everything that is being invented will have an owner before or less. And clarifying these rules very early on is just commonly wise thing to do to avoid problems further down the line. It also believed that intellectual property rights stimulates innovation. And this is the basic premise that if you gain from an innovation, well, you are more motivated to start to innovate and develop new technologies and so on. And thereby, it also helps to promote new technologies. It also, if through the IP system, makes the technologies more visible. We'll come back to that later on, but basically an technology that has a patent will also be publicly available in terms of information. And then, of course, it helps secure the local inventors' rights and benefits. So if you're a small player, then you will actually have specified or towards, let's say, big companies or big research institutions or big foundations that you actually have specific rights here. So therefore, we believe in general that IP rights should be seen as an opportunity, as a security, as a safeguard, as a protection, more than it actually should be seen as a barrier. And I hope that after this presentation, it'll be a little bit more clear why we believe this. Now, IP rights in the innovation ecosystem. The innovation ecosystem is many things, and it's basically everything in a society that leads to promoting innovation. And it starts right away from education, from primary school up to secondary school, and of course in universities. And this means that there should be investment in education. There should be a good human capital to be able to go in and develop things. It's also investment in research and development. It's access to capital, both private capital, government capital, venture capital, and so on. It's that there are professional services available, that there are managers, lawyers, business managers, other kinds of banks and so on that understands what it takes to bring innovation to the market or just to get it out there. There needs to be a relatively well-functioning IP system where there are laws in place and that these laws are enforced. And there need to be various laws and policies that supports research and technological development. And that can be in relation to marketing, distribution, and so on. It basically is a matter of having law and order in a society and not too much promotion or corruption and other things that might disturb that picture. And then, of course, you need to have entrepreneurial willingness. So in some countries, you hear people talk about, the young people, they don't want to go out and do their own business. They just want to work for the government or something like that. In other societies, it's completely different. But is it a factor? Is there really a motivation? Is there a lust to go in and start building your own business or doing your own things or creating something for yourself? So IP is then part of all this. It goes into several players of this. It's not the thing that has to be there, but it's one of the things that has to be in place in order for a society to be highly performing in terms of innovation and development. Now, benefits of the IP system. I mentioned it a few times already, but basically it's about clarifying ownership. And we think that's important for diffusion because if something is good business, then you can be pretty sure that it's going to take up really fast. If it has to be forced through because it's a political agenda or something, then it's not necessarily the uptake is there. But make it into a good business, make sure that people can make money on this, then you'll see how fast it can go. And I think this is something that not only is relating to agricultural research, but when we talk about climate change in general and other things, this is a factor that should be kept in mind. IP may be helping to make things, innovation into good business. And one of the ways it does that is, again, it clarifies ownership. When ownership it clarifies, there will be less risk for investing in the new innovation, the new invention. So it's easier for a bank or a fund or whatever it is to argue towards their shareholders, their boards, that we should invest in this because these guys actually have a patent already, and thereby we have some, shall we say, some security against copying and against others going out and competing in that specific space. That has to do with it creates this confidence of being shared, and then it also empowers the inventor to engage with big players in commercialization. Let's say that you're a small research lab and you're being approached by a big international company or a big local company who wants to use your invention for various goals. Well, if you are the sole owner of the invention and you have secured your rights through a patent, well, then you have a very strong negotiation point. And that goes also when we look at the relationship between rich and poor countries and rich and poor institutions, that it might level the playing field between these and thereby help to bring also the small inventors to just have the good idea and give them the power to actually be able to implement that idea. Now, basically, intellectual property, what it's about creations of the mind. So it's protected by national laws and international treaties. And national laws is really the most central part here, because every country have their own laws in relation to intellectual property, and you won't get any further than these national laws in principle. There are a number of treaties. I mentioned that we have administered 23 treaties here in the house, but they are not necessarily a global patent or something like that. That doesn't exist. It's all a matter of national laws. Again, it enables people to earn recognition and financial benefit from what they create. And again, there is a broader public, shall we say, interest in getting these IP rights in place, because it also fosters the development of new innovation, and it makes them more publicly accessible, so that we might end up with very nice and useful inventions like the mustache guard that we have here from 1876. Now, what does this consist of? There are certain, we call them assets within intellectual property, and it depends very much on what it is, the nature of your invention or your technology. So if we talk about innovative products and processes, then we're dealing with patents. If we talk about a specific sign, then it's a trademark. If it's a design, then we have design rights. If it's cultural, artistic, and literary work, well, then it's a normal copyright. If it's confidential business information, then it's trade secrets. And if it's something that is very specific to a geographical region or origin, well, then we call it geographical indications. Now, we're not going to go through all these in detail. We'll be talking quite a lot about patents, and we'll just go very briefly into some of the others, because some of them at least might have some relevance for the context we're talking about here. Now, going to patents. So this is the most relevant for the kind of work that happens in CGI institutions. Normally, a patent is not a lifetime thing. It's normally something that is granted for 20 years. Again, all this depends a little bit on national laws, but this is pretty general. It applies to a specific territory. So meaning that if you get a patent in a certain country, but it's only valid there. It's not valid in the neighbor country unless you have also got a patent in that country. Once you got the right, they can be enforced in courts. So you can go to the court and make a complaint if somebody is infringing your rights. It can also be challenged. It can also be invalidated, and that can happen both through administrative procedures, that is through the National Patent Office or others before it's granted, or when it's granted, it can happen in the court. So if you found out that somebody has taken patent on something that you believe that you have actually invented before, well, then you can go to the court and contest that patent that has been done and maybe even have it invalidated. Now, the basic thing about a patent is that it gives you, as an inventor, as the owner of a new technology, the right to decide who uses this invention and how during the 20 years that you normally would get the patent for. You can decide to transfer your rights, you can license your rights, you can sell your rights, or you can give them away for free, or you can just choose not to do anything with them. And we'll get back to that a little bit later, why this might also be interesting in relation to CGIAR. So after the expiry, the invention enters into the public domain. So after the 20 years, patent is finished. It's open to everybody to use. It's not even a copy anymore. It's basically just is there for the public benefit. There's no specific exclusive rights anymore. Now, the patent is gained through making an application. Now, basically, the origin of the word patent is lay open, and this is a really basic things in relation to patent is that yes, you get the right by the state to exclude others from using or exploiting your invention for a certain part of time. But in order to get that right, you also have to disclose your invention to the public. So when you make an application, so you file it, and then you have to include all claims. Claims is basically a description of what you believe that why this invention is unique. You need to have a description of the invention itself, including abstracts and drawings and so on. And these should be so detailed that others can go in and work on point of departure in that work. Of course, they're not allowed to go in and copy it if the patent has been given in that specific country, but they are allowed to continue to develop the same technology already developed. So that means that in order to get a patent, you also lay it out open to the public, and thereby you also contribute to the general knowledge of society, technological knowledge, innovation knowledge, what is possible and what can be done. And that information can actually be used to some interesting things, and we'll go back to that later on. Now, in order to get a patent, there are certain criteria, of course, and this is where it gets a little bit complicated. Also because, again, we are down on national laws. So this is in general how it is. It may differ in details from country to country. But generally, a technology or an innovation should have practical use. It should be new, so meaning that you should be able to do a search for what we call prior art, existing technologies, and not be able to find something that corresponds to this. It should have an inventive step, meaning that it shouldn't be obvious. It should be something that's really, is special, is not unique, but is something that is not something that everybody would think about, like, I don't know what. And it should be patentable. So it's not everything that can be patented. For example, you can't patent a theory, you can't patent a method, you can't patent natural materials. That one is a little bit tricky because different countries have different rules. And there are medical treatment methods that you cannot. It doesn't mean, of course, medical products you can, but methods as such you cannot. Now, where do you then get your patents from? Well, you make an application, as mentioned previously, and that application you can send to your national patent office. So every country, I think, have a patent office by now, and they are the ones who will then evaluate the application against what is already out there, making searches for seeing if there are existing technologies and so on. We also have regional patent offices, and one of the biggest is the European Patent Office. Some of these regional patent offices can also grant a patent under different conditions. And then we have the Patent Cooperation Treaty. This is what administered in this building here by WIPO. And this is not a patent, but it is a filing system. So the idea is that you make one filing for international patent application that can cover multiple countries, and that will help the process. It'll make it faster and cheaper and simpler to some degree in order to get it. But you don't automatically get it in the countries that you're applying for. It still has to go through the national patent offices. And again, because the whole patent system is based on national laws. There's not a worldwide international patent as such. So this can be filed for the PCT system, which has these advantages, as I just mentioned. So it can be filed both nationally and also to our international bureau here in the house. As part of that application, then what will be done is an international search report will be made, and that will be made by an international searching authority, which is basically has been given the authority to make a search for any prior art, any prior innovations that might make it impossible to provide give the patent to this application. Now, so basically, to sum up what the patents are about, the essentials are here. So it basically means that once a patent is granted in a country, no third party can apply for a patent for the same invention. In the country where the patent is granted, the patent owner decides who used the invention and how. In a country where the patent has not been applied for, has not been given, anybody can copy and sell the invention, but they cannot patent it. So you're still the owner, except that in this specific country, you cannot specify how it's going to be used. If no patent is granted, there's a risk that a third party will try to patent the invention and sell it. And basically that means that if you have the invention and there is a risk that somebody will go out and take patent on it and basically become the owner of it. So in other words, in very simple, the patent protects against third-party patenting and against copy in the country of a patent where it has been given. So you can see the patent system is not a foolproof protection. It doesn't protect against everything, but basically it's the best that is out there. It's the best, or sometimes the only real protection you can obtain against use of your invention in ways that you do not want to happen. And we'll get back to that later on, what that also means. Now, we looked a little bit into how many patents and how it's being used by the CGRI members. And in our system, the PCT system, there's not that much to be found. So we have a database here in the hall called PatentScope. It has more than 72 million patents from both the PCT system, but also from other systems. And when we make a search for example, ILRI, we only get 12 patents in there. And as you can see, if you can read it, they basically are the same patent in different countries for about 3 different technologies. So that's not a lot. Most of the other CGR organizations, we could not immediately find anything. If you look into the East Coast fever vaccine here from ILRI, then you can see what it looks like here. So basically what it consists of is 85 claims, 79 pages description, and 20 drawings. Again, the idea is that this information is publicly available. Everybody can go in and make the search as we did in our PatentScope database, and there are other databases out there also. Even Google has made a version of this, and thereby see all this detailed information describing this specific patent. Again, this is what you have to do in order to get a patent. It becomes part of global common knowledge, so to speak. So we looked at IRI also, and of course, IRI has a very long and relatively well-known history also in Southeast Asia for rice production. So they are a little bit more active. We found 25 patents in there. But again, many of them are the same. So it boils down to, I think, 4 or 5 different technologies. You can see them here. Now, of course, if we look into the private sector, somebody like Monsanto, now part of Bayer, and we do the same search, well, you'll see that in our PatentScope system, we could find almost 44,000 patents, of which a big part of those, a small part of those were PCT. But this is, of course, a very good expression that, you know, the private sector, of course, they live from this, they have to do this. So this is one of their primary tools. And I'm sure that the people in this webinar are well aware of some of the problems associated with this. If you look actually by chance, the first one that comes up here is actually in relation to making a paste, a glycophosphate paste. So one of the more famous products from Monsanto. But this is just one patent in relation to the production of that material. Now, this was a private sector, but in relation to CGRI and public research, there also can be good cases for doing this. Now, I have a specific case here. So this is a Dr. Ramon Barber. Some of you may be familiar with him, but he is a Philippine who discovered that potassium nitrate is a very effective agent for inducing flowering in mangoes, and that can increase the production quite a lot. But when he discovered this, and this goes back a number of years, he did not think about patenting really. And he didn't think about it until he certainly discovered that there was somebody else was trying to apply for a patent for his invention. And that he was not so happy about. So he contested the application and it was rejected because he could prove that his research notes that he had actually working on this before, and he had already, he was already the rightful inventor of this technology. So he was awarded the patent in the Philippines. So basically, it's the patent system secured his rights and enabled him to prevent, for example, a third party who wanted to exploit it economically and wanted to exclude others to be able to use it. He prevented that. He did not enforce his patent, he didn't use it, but once he has got the right, he could make sure that third party was not able to exploit his invention in a way that he was not happy with. So even though he's got a patent, it can still be laid open for public use as wished for. Another case here, so this is more, we're going into the business side, but this is a very nice and relatively clear example from a small and medium scale enterprise from Argentina. They're called Synthesis. And what they did is that they invented an inoculant for soybeans. They got a patent in Argentina, they developed the business there, and then they want to go international also. The way they did that was that they contracted distributors in foreign markets, and then applied through the distributors, applied for patents in these markets. So meaning that they didn't have the possibility themselves to go out and establish themselves in various countries, but except they made a contract with a local distributor, got the patents in these countries to make sure that the local distributor would be interested in going into this and could make money on it. And then they actually ended up with having a very strong growth and was later bought up by a large Indian company. So a way of showing how, as a small business, the IP system can help you to expand your business in the international market in a relatively secure way. Another case here is from France. So the INRA, the International National Institute for Agricultural Research in France, in some years ago, they invented something called the Okura, which is a method to produce high yielding rapeseed. Now, INRA is a public research institution, but they decided that it would be easier for them or better for them to reach a larger market by having a patent and then grant licenses. We'll talk a little bit more about licenses and how that works later on. But basically, this is one of the options that you have. If you want to give others the right to use your invention, you can make a license. And in this case, it was non-exclusive. So that means that there were different companies who could get the same license, the same right to use their method to produce high-yielding rapeseeds. This was very good for diffusion because that meant that not INRI, but actually the seed companies could then develop various types of various varieties of rapeseed that suited the different climatic conditions in France. And it also provided a revenue stream for INRA. So what they did in their licensing agreements was that they put in a 5% royalty up until 2011, and then a 1% royalty up until 2016. And this meant that INRA was able to generate a rather substantial revenue stream, which helped them to recuperate some of their costs in relation to the research. And finally, a case not from agriculture, but from medicine, of a case that is maybe a little bit sad in relation to patents, but the 2UU here, she discovered artemisinin as an effective remedy against malaria in the 80s. At that time, there wasn't a patent office in China, so there was no patent that was applied for. And it resulted in that a non-Chinese company actually was awarded the patent later on. So this meant that a lot of the benefits from its invention actually did not go to China or Chinese companies who went to abroad, even though they did reach a deal with the patent holder and some sharing was done. But nevertheless, Zhu Yuyu, she won the Nobel Prize in Medicine in 2015. So that I'm sure is a lot worth for her. But this is a kind of, a kind of the case showing that if you're not careful about securing your rights, this is some of the risks that you may encounter. So this is enough for patents in this time, and you're very welcome to post questions, and we have time for discussion afterwards to go more into some of these issues here. And I'm now shortly introducing some of the other ways that that patents, that IP rights can be protected. So some see trade secrets as a kind of alternative to patents. If you don't want to do a patent, meaning you don't want to take the risk of laying your invention open in countries to be exploited in countries where you don't have a patent, well, you can keep it as a secret. And that, of course, is an option. And there are some very well-known cases where this is being done. You can see there's an illustration for Google here. The algorithm behind the Google search machine is a trade secret. The famous Coca-Cola recipe is of the ingredients and their relations is a trade secret also. So again, it depends a little bit on the legal system and how it's defined and how it is being protected. But there's not a system protection as such. There's no registration. So the way that it's often is done is through confidentiality agreements with your staff. The people who are going to has to know your secret, because otherwise they wouldn't be able to work on it. You make sure that you have a legally binding agreement with them that they are not allowed to disclose any secrets. And that's normally how it's done. It's a bit difficult if your invention is something that is up where you can actually see how it works and can be taken apart. Remember that reverse engineering is not illegal. So if your invention is a mechanical thing, well, then it will be very difficult to keep it as a trade secret. There may be know-how in order to use it and so on that could be used as a secret, but in general, this kind of protection is relatively weak compared to patents, because it's only as good as long as you can actually effectively keep it as a secret. Now, there's something called plant breeders' rights. And there is something called the International Convention for the Protection of New Varieties of Plants, as is mentioned here on the screen. Now, this is administered by UPOV with the International Union for the Protection of New Varieties of Plants, which are also based here in the house, even though they're not really part of WIPO as such, but we just host them here. Now, the idea about that is that when you breed a new variety of plant, you as a plant breeder have the right to that new variety. Again, there are some criteria. And you can see them here. It should be new, it should be distinct, it should be uniform, meaning that every time you propagate it, it should be the same product again. It should be stable. That's the longer term dimension of the same thing. And it should have a suitable name also. This is related very much to WTO and the TRIPS agreement. So if you have a WTO, your country has a WTO membership, well, then you are also committed to the UPOV plant variety or plant breeders' rights protection. Now, there are many things to this, and we are not experts in this field specifically, but the general conditions are that organisms that are already in nature and natural processes in general cannot be patented. It gives you the right to control the production and also reproduction of seeds. And I know that this has been a contested area for some of the private companies, for example, that small-scale farmers are not allowed to generate their own seeds. But further down, actually, the UPO does allow for member countries to let farmers use harvests for propagation, as they say, within reasonable limits. And what these reasonable limits are, I'm not at limit to say, and I think that depends very much on the national laws. There is no authorization required either for non-commercial use of plant varieties, for experimental use, for breeding and exploiting other varieties that stems from this first variety. So if the protection period is like for patents, except that for trees and wines, that is a little bit longer. But this is a special area for plant breeders, and it might have some relevance for you. And there's a very informative homepage here in WIPO Green, in WIPO, where you can look into the details of how the UPO functions. Finally, trademarks. So this is maybe not so relevant for the kind of work that is being done here, but we'll nevertheless just mention it, that it is basically signs as you know them from everywhere. It is registered, it's territorial, it's for 10 years, but it can be renewed all the time. And it can also be collective marks, so basically where it's an association which controls quality through an agreed standard. And that can be quite interesting, for example, from small-scale farmers who can group together in the cooperative or something like that, and thereby sell their product as being having a special quality or something. The case here is, for example, for fair trade. And then also domain names, they are also protected against cyber squatting, meaning that if you are the owner of a trade name, a trademark, then nobody, a third party is not allowed to use that as a domain name. And there is an arbitration body just been set up in WIPO recently to deal with this. So copyright might be relevant for the work there. It's very well generally known, I think. So there's no registration. It's automatically being acquired when a work is being done. There may be some countries that has the possibility of doing registration, or where you can deposit your copyrighted work, so they can be referred to if there's any compensation later on. But basically, for the work that you're doing, it would be databases, it would be articles, books, and so on and so forth. Again, ideas cannot be copyrighted, but the expression of ideas can. Normally, there's no need to do anything specifically to obtain copyright. It's obtained automatically, and it lasts for your lifetime, plus 50 years. Now, finished with the assets, then I'll shortly talk a little bit about what the patents information that is made publicly available, what that can also be used for. I mentioned before that patents information is out there publicly and freely available. Now, in the database that we have here in the house, we have 72 million, more than 72 million patents. So all this data, of course, says something about what's going on in relation to innovation and new technological development. And in WIPO here, we produce something called the Global Innovation Index every year. It's a big report. The last one from 2019 just came out recently, and it's available for free download at our homepage. And from there is an analysis of what is going on in invention globally. And you can see that in key findings, as they're here on the screen, is some of the things that can be learned from this. For example, whether the global level of innovation is in a healthy state at the moment, or whether it is, for example, affected by economic slowdown, in which global areas there's a lot of things happening, in which ones there's not so much happening, and so on and so forth. And then there's an index where the different countries are being evaluated or assessed against one another on about 80 different indicators in relation to what I mentioned in the beginning, the innovation ecosystem, where all different kinds of factors in society that help to contribute to innovation. And then you can produce a nice map like this, which shows where there are the most important clusters in relation to patent applications and new innovation output. You can also try to look into the different regions, how much they produce in relation to innovation, and you can see North America, Europe, and China are some of the major innovation centers, which may not be so surprising. And it may not be so surprising because we can also see that there's a pretty close relationship between gross domestic product, that is the general indicator of welfare in a society, and how much innovation you're able to produce. Now, in this little nice graphic here, you got the GDP on the x-axis, and it's exponential, and then you have it's a logarithmic scale, and then you have the index going up on the y-scale. So you can see that basically, if you can see that all the way up in the top, where you got a high GDP and a high index of innovation, is basically European countries, and then you got the very big blue glob there a little bit to the left, that is China. And then you have various other groups of countries, and they are colored according to groups of whether they perform kind of above or below a kind of statistically perceived trend for where they would normally be compared to their GDP. So this can be quite interesting indicators of where innovation is taking place. And if you go into deeper, you may also be able to actually see some causalities, understand a little bit what it is that really makes some countries being able to be in the forefront in innovations and others not. And with that, oh yeah, there's a small case here for something that's interesting in relation to green energy technologies. So last year's Global Innovation Index report pointed out that innovation in green energy technologies, so that solar panels and so on, windmills and so on, has actually decreased since 2000 and, can't read it, but in the last few years. And the explanation for this is most likely has to do with that some of the public subsidies have been removed, but also that it's a more mature technology now, so therefore it's more difficult to come up with new inventions for which you can get a patent. With that, I leave to Anja to continue.
Thank you. How do I move forward on this? So Peter has shown part of the innovation system. So the innovation is all about finding new solutions to problems that we all face. I'll focus my presentation more on how do we disseminate innovation and technology, and what can Green do to help with that. So technology transfer, what are we talking about? We're talking about spreading both knowledge and technology. This can take many forms, and sometimes there's some perceived vision of technology transfer being between state actors. Most of the time that's not the case. Most of the time we talk about either individuals or organizations that exchange knowledge in various forms. That could be researchers spending some time in a different laboratorium or in a company. It can be research collaborations. It can be buying products. It can be really in very different ways. Another point is that, and that relates to what I've just said before, especially if you talk about technology, most of the time, it's also very important to have access to knowledge around it. And I'll get to that more when I speak about licensing. Depending on what the technology transfer is about, it can be about the ability to manufacture, to use, to develop, to improve, and to sell or distribute technology. Again, depending what form technology transfer takes, it also, making it successful also depends on the capacity of the recipient side in terms of how can the persons working there absorb the technology, but also how can or how does the organization adapt to new technologies, and how can they be integrated into processes and procedures. Again, if we talk look at a broader level, that also the ecosystem around it can have implications for that. Very often we are faced with the question whether patents actually foster or are a barrier for technology transfer. Personally, I think that question doesn't lead to much in itself, because it really depends what the patent is about, what are competing technologies, how is the policy of the patent owner making a patent or technology available, and also what's the situation in the country. And that refers to what Peter said before in terms of using information that's contained in patents that is being made available through the patent system and the underlying contract of the patent system, that in order to get the protection, you make available the information, and that information can be freely used everywhere, but in particular in countries where no patents are sought, because then you can also carry out those activities that a patent owner can prevent you from doing in the country where a patent is granted. Again, as with the innovation system, also the system for technology has other factors. It's not only about IP, it's also about what is the system in terms of trade, what is the openness of the markets. We already talked about adaptation capacity, what other policy tools exist or what other policies exist. I think that hasn't been mentioned, but a very powerful tool for incentivizing innovation is if you have laws that the companies or the organizations need to comply with. Like if you have stricter environmental rules, then there's an incentive for organizations and companies to innovate in order to meet those standards. Then you have the finance aspect, and you have also the aspect of the degree to what extent private and public sectors interact, and I'll come to that in more detail later on. A specific case, as I said, technology transfer can take many forms. If we talk about IP rights, very often we talk about licensing, even though patents or other IP rights can also be sold to someone else outright. But the licensing agreement is a specific form of a contract between the owner of the IP right, that could be the patent owner, and the recipient, whereby both parties agree on what kind of uses the owner will allow the recipient to make use, and also in what territories. And this is very important in terms of also from a public research institute perspective, because through the licensing and the ownership of the intellectual property, you can actually decide what is going to happen with the invention or the technology that you've worked on. You can either decide to make it available in a non-exclusive way, which means that you can have different licensees, and there are various ways of breaking up these licensees. And you can also have on the other end, the exclusive variation, where you just have one licensee who whom you're conferring the rights to, for instance, to manufacture and sell the product that's being developed on the basis of the patent. And there are different arguments for and against it, or not so much for and against it, but it really depends on your policy on how you want to make the underlying invention available, and also where there are greater prospects of having a product that would benefit. And again, I'm saying that from a public research institution perspective, in terms of we have to remember what our objectives are, and whether making products that are based on the research available is better served through a non-exclusive or exclusive way of making the technology available. Another thing that we should bear in mind is that very often licensing doesn't only cover the, for instance, patent as such, but it's very much very important to make also know-how or materials available, and especially in a context of agricultural research and development. And then in terms of something going wrong, we also have to, there also means that balance the exclusivity of the rights of the patent owner, which can be done through compulsory licensing. And there are various grounds for doing so. And sort of compulsory licensing basically means that the patent owner is forced by a government entity to make the patent available. That could be the case of a national emergency, but there are also other grounds for that, such as competition law grounds if the patent is actually blocking. Again, coming to the perspective of public research institutions, Peter said in the beginning that research is not being carried out to necessarily to generate revenue, but to make the fruits of that research available for the benefit of society. How does IP come into play in this question? It comes into play at various levels. It comes into play when either carrying out research in the institution, but also when you decide to collaborate with other organizations or other institutions and to carry out joint research. So it's good to have IP policies in place from also organizational perspective on how you want to go about protecting your assets or preventing others. That's what Peter said also before, preventing others from protecting what you have come up with. Then next level on in collaborations with other organizations. How do we deal with IPR that each party brings to the table? How do we deal with the resulting IPR that comes out of such a collaboration? Then again, well, obviously, if we decide that we want to go the patenting way, we have to check whether patentability requirements are met. Ideally, that's done by an expert in that. And obviously, these considerations should be done before publishing the results of the research, because that could prevent the patentability criteria to be met. And then, and that relates to what I said before, we also have to consider these IPR questions when we come to the dissemination and transfer phase, because it has implications the way in which we want to go, making the fruits of the research broadly available, or going the exclusive way, because there are arguments in favor of doing that. And again, it's a tool to decide, IPRs are a tool to decide how you want to deal with it and how you want to make the invention available, so that no one else can come and decide and exploit the invention in a way that you don't want, like, for instance, not making available. And a lot of ethical considerations are also linked to that. There's also the famous case of the breast cancer genes that have been patented, and the test has been made available on really prohibitive costs and in a very restrictive ways. And having patents yourself gives you puts you in a position to decide how you want to go about that. And that's really one of the most important points that we want to drive home today, that it puts you in a position to decide. Coming to WIPO Green, that relates to what I've said before on enabling factors for technology transfer. And one of the very important parts is the public and private sector interaction that contributes to the dissemination of green technology. Why do we as WIPO engage in such an endeavor? That really stems from the fact that IP and innovation aren't done as they aren't ends in themselves, but they're meant to contribute to solving the challenges that we all face. And you've also mentioned before that these are expressed in the Sustainable Development Goals. So WIPO's green mandate comes from the fact that we're supposed to contribute to solving global challenges and to contribute to the technology transfer that can help address the problem of climate change, but other environmental challenges and food security challenges as well. That's why we launched WIPO Green in 2013 as a public-private marketplace that promotes green tech innovation and diffusion by connecting those who are looking for green technology solutions with those who make them available. And we have as an objective to contribute to a more efficient adaptation deployment of those solutions. We also provide a platform for innovation and innovators, particularly from the developing world. And we engage closely with the private sector, which is the source of 80% of innovation in the green space. And by gaining experience and capturing these experience, we also contribute to the policy dialogue and on the factors that make the innovation system or that are important for the innovation system to function. We work with a network of 89 partners, which come from various sectors. So as I said, both private and public sector, ranging from multinational companies, research institutions, NGOs to other sister environmental intergovernmental organizations. With those, we collaborate on events and projects and also provide insight and advice. There's no fee for them to participate, but they support our work. This is the content, because the second component apart from the network is the database. This is how a snapshot of how the database currently looks. So there are 8 fields ranging from building constructions, energy, transportation, chemicals and advanced materials, green products, farming and forestry, water, and pollution and waste. And at the moment, the energy sector is the biggest field. The farming and forestry, which might be of more relevance to you, is one of the smaller areas. But that's something that we're also hoping to change. But we'll come to that when we go to the discussion. That's actually a slide that's difficult to read. The idea here is to show that there are different levels of technology readiness, again, ranging from R&D. One point maybe that is of importance is that we would like to have not very early stage research, but starting from a technology readiness level of having prototype tested in a real environment. Then there are technologies at usable level and also fully commercialized products, which are around 1/3 of the content of the database. One important point that I also mentioned in the beginning, because our goal is to have or make the dissemination happen through making connections, is our acceleration work or the matchmaking work, which we've done basically once per year, where we pick different geographical areas and different themes or issues. And we work to identify concrete needs in these areas for those issues, and then connect providers and seekers. We've done that, as I said, almost every year. And at the moment, and we'll come to that, we're focusing on climate smart agriculture in Chile, Brazil, and Argentina. Then also we have user-led matchmaking through the database, which is accessible for free, and then also facilitated matchmaking at the request of our partners. So I mentioned the recent acceleration project, which is taking place in Chile, Brazil, and Argentina. Again, as I said, the methodologies that we work with local partners who identify specific technology and innovation challenges. This time we focus on climate smart agriculture. And the partners that we work with are the intellectual property offices in the countries, but also the ministries of agriculture, the producer associations, and the Inter-American Development Bank. We've just launched and foresee a very intensive phase until the end of the year, and then wrapping up and following through early next year. So for this, there's not so much more that I have to mention, maybe just that the needs are local, but the solutions can come both from the countries that we mentioned and also from abroad. Just more specifically on the climate smart agriculture in Chile, we focus on the wine production, in Brazil on zero-till, and in Argentina, it's not fully finalized, but most likely on crop rotation, soil recarbonization, zero-till, and cattle rearing. So if you want to participate in that, don't hesitate to contact us, but we can also discuss more in our discussion. Just quickly on overall user benefits, obviously, as our goal is to contribute to dissemination and transfer of technology, we provide the possibility to connect with the members of the network, We provide you with free of charge international promotion. We've also have a track record for connections that have been facilitated either through the database or the acceleration projects. And also you can participate in activities that WIPO Green is organizing, such as the acceleration events, the exhibitions, partner events, and mediation arbitration services discount. All you have to do is to register through the database, and then if you are an organization, you can also submit technologies or need. Other tools that I want to briefly mention is a licensing checklist. That's a very helpful tool for those who are not so familiar with licensing issues. It basically provides you with a checklist of issues that you should consider before entering into negotiations, and in order to plan and prepare for reaching an agreement that is freely available on our website. And then WIPO as such, outside of WIPO Green, offers different services for inventors that are available for free, which is the patent scope database that Peter already mentioned, where you can have access to patent documents, the TISC centers, which are very important, that provide innovators in developing countries with access to IP information and related services. Peter also mentioned already the Academy, who provides trainings and courses and materials. And then there's also the Access to Research for Development and Innovation program, where you can have access to scientific and technical information. And then last but not least, the SMEs and Entrepreneurship Support Division, who provide training and further capacity building. With that, I come to the very last slide, which is on the Inventor Assistance Program, which is a joint initiative between WIPO and the World Economic Forum, which helps innovators to seek patent protection for their inventions. So it's mainly helping to with the procedures to file for patent protection. And this is available in a limited number of countries. At the moment, it's Colombia, Ecuador, Morocco, Philippines, and South Africa. Just to quickly wrap up before we go into the discussion, a quick recap. So IPR is both relevant for public and private sector institutions, and it's not only relevant for non-commercial, but for the reasons that we both outlined, also for non-commercial technology diffusion. IPR protection is instrumental for technology transfer because it helps shape the relationship between the owner and the recipient of the technology. We've said that numerous times, but I think it can't be said enough. And I think that also relates to this question of barrier or supporting technology transfer and innovation. It's part of the system of innovation, but it's only one element. There are other elements that are important. You can use the IP intelligence to detect technology trends and innovation clusters. And you can use tools like WIPO Green to identify and compare technologies and contact technology owners and enter into collaboration. So with that, I'd like to thank you for your attention and also hand over to Peter for additional sort of preliminary concluding remarks before we go into the discussion.
No, but I think that's fine. I think from here on we'll leave it over to Ariana to see if there's any questions and any points for further discussion.
Absolutely. Thank you for a great presentation so far. I think it might actually be best if you keep the slides up on the screen for right now. So thank you for having them there. One question that's coming in from our audience is about what's specifically on the slide right now. They said that they really appreciated the overview of the fundamentals of IPR and that they were hoping to understand more specifically how this connects to the mission of CGIAR. So the specific question ended at, how can IP management and tech transfer accelerate the assembly and delivery of agricultural innovation to address pressing global food security issues? So they did give one example too, for example, developing heat and drought-resistant maize in East Africa.
Okay, big question. Small answer, I think. So I think we, in the beginning of the presentation, we touched a little bit of some of these issues, why this has more general use for example, the CGIAR. Now, when we're talking about new plant varieties, for example, varieties as mentioned that can be part of the combat against climate change or adaptation to climate change, then we are back again at first, the whole IP system starts with the inventor, of course, and the rights of the inventor. And we mentioned the UPOV, the plant breeders' rights, which comes into play, and how the IP system can protect the invention, for example, the new plant varieties, from being exploited by third party in the way that was not really the intention from the beginning. And then, of course, the other side of it is the whole technology transfer issue, which was touched upon in the last few slides here, that in general, if you want to get things out in the market, it's a good idea very often to have the IP rights clarified from the beginning so that you don't get into a contested field before or later. Now, how then you want to then make this new technology, let's say new plant varieties that are more drought tolerant, how you want them to make available to big commercial farms, which may have international stakeholders, or small family-based households, which is very typical in Africa. That's really up to you, once you have your rights, to decide that. If you don't have the rights, it might be a little bit more difficult to control whether the ones you actually were intended to should benefit from your innovation, whether they will also be the final beneficiaries. So you could, for example, specify that in a certain country where you have the rights for your invention, you can specify that if you are a family-based household or a vulnerable household headed by a single head of household and so forth, or having under a certain wealth threshold or so on, and you can say, well, if you are so and so category, you are allowed to use this new plant variety for your own propagation and to whatever means that you want to do. On the other hand, if you're a large commercial farm exporting to the international market, maybe even having international stakeholders and investors, well, then the rules of the game may be different, and that may actually be something that could contribute to a revenue stream for your research organization. I don't know if that was...
That was great, very detailed and thorough. I did want to give a brief opportunity to see if Rodrigo or Brian had anything they wanted to add, or if they wanted to leave it at that for now.
This is Brian, I think. Go ahead. Yeah, go ahead, Rodrigo.
Sorry, Brian. Hopefully you can hear me okay. There were some issues with my microphone earlier. Just a very quick question. You mentioned that sustainable technologies, the incidence of patenting of sustainable technologies in developing countries tends to be lower. And just wondering what kind of approaches do you recommend for overcoming those hurdles, or whether approaches you recommend from your office or examples you've seen across the catalog of technologies that you deal with?
Take that question. I think that's in line with the overall innovative capacity or activity in those countries. So it's not only true for green technologies. and the innovation index highlights the factors that have a bearing on the innovation outputs. And I know that countries are using those to see what they can tweak in the system so that their performance gets better. And I think what otherwise WIPO is doing is to provide the capacity building to be able to use the intellectual property system to the benefit of the developing countries, and to provide the developing countries innovators with a platform to promote their innovation, which is, for instance, also what WIPO Green does.
I could also add that I think the reason we mention that is that often, well, in some cases, IP right is used as an argument to say that it actually hinders development, and there can be found cases of it. And this was more an argument to say that when we are talking green technology, it's a little bit particular because only about 1% of the green technologies are actually being patented in the developing countries, and that's mostly because it's not considered as a very important market. It's costly to get a patent in a certain market, and therefore a patent or an innovation holder will normally carefully evaluate which markets would be most interesting. So this was maybe the other way around the argument, saying that because in most developing countries, actually a very small part of the green technologies that are available are actually not patented, and therefore they're freely to be used. So therefore the IP system is not a hindrance. But of course, it is not an advantage for the IP owner, but it was in relation to that. But of course, we're talking green technology here. We're not talking plant varieties and stuff like that, because there the picture might be quite different, especially when we talk on seeds from big multinational seed and agrochemical companies.
Thanks for that.
And I do see one question here that's coming in about one of the slides that you all had shown. So they were talking about the slide with the bubble size by population, and I think it was GDP per capita. And I think there was just a request if we could go back to that and just review it one more time and what that truly indicated. I think it's this one, yes.
So you want me to explain a little bit again what it shows?
Yeah, I think that's what they're asking for.
Right. So the idea is, again, the connection between global normal wealth in a country and then the level of innovation. So the two factors that are plotted against one another here is a global innovation index score, so which is a composite index based on about 80 different indicators for what constitutes factors that are normally considered to be conducive for an innovative environment. So the higher you are on that, you also, and it's combined also with how many patent applications actually coming out from that country. So it's a complex statistical exercise, but what it reveals is a picture like this, basically just showing that the more wealthy countries are also the ones that are scoring highest in terms of innovation. This is basically where innovation is coming from in the world as of today. And we got a trend line there, which kind of shows where the kind of middle field would be, and therefore some of these countries has been then grouped according to color in relation to whether they are more performing what would be expected from their GDP according to this very broad picture, or whether they are overperforming in relation to that. So it is a very aggregate view on a statistical correlation between wealth of nations and their capacity to innovate and develop new technologies.
There's one point that is related to that, but which is a very interesting trend in the sense that the picture of those countries that innovate is becoming more varied and more diverse. And I mean, we've most obviously seen that with regard to many Asian countries, which have overtaken, like especially China, overtaken some of the European countries in terms of the innovative activities. And we've done also some research on green technologies, where that has been also shown that the innovation landscape is becoming more varied, and which is a good sign, even though the most prominent actors, some of the most prominent actors are still the same, but we've seen some new innovation clusters there which are appearing.
Thank you, Anya, and also Dr. Oxen. I think that really helped clarify. If there's any further follow-up questions about that, I'm sure that they'll put them in the chat. And I'm just looking now and seeing that we're getting pretty close to wrapping up here and wanting to finish on time. So I just wanted to pass it off to anyone who wanted to offer any final remarks about this presentation, as we see if any final questions roll in this last minute or so. I'll go ahead and turn our screen share off now. So any final remarks, I suppose, from Brian or any of the other panelists that are with us today?
Thank you. Thanks a lot, Jan, Peter, and Anya, for going into depth and breadth about where intellectual property rights and the mission of CGIAR appear to have some good points of intersection. One of my understandings about WIPO generally, and this would obviously apply to WIPO Green, is that it need not be necessarily, restricted or patented technologies that could also feed into this discovery and transfer kind of process. Is that an accurate statement?
Yes, that's correct. It can be patented, but it doesn't have to be.
Mm-hmm.
I mean, also the decision whether something, I think we said that before, whether something should be patented is a conscious decision. First of all, whether it meets the patentability criteria, but also whether it's worth paying the fees and the countries that you go to. But many relevant technologies also aren't patented, and they can still be part of the WIPO Green system.
That's thank you for that clarification, because I think it really it sort of drives home the point that there, across the whole spectrum of kind of nuance related to intellectual property that CGIAR works, WIPO and WIPO Green also work. And so I think it would be really interesting to explore kind of multiple ways in which we do intersect, from everything from entirely open technologies that could benefit from some more sort of discovery and hopefully some technology transfer, and then also managing the nuance of where intellectual property rights, as several of the examples showed, would actually help us to push closer to delivery on our mission as well. So thank you. From my side, I think that it's confirmed there's a really great opportunity here to explore further.
Great. Well, thank you very much. I think from our side, it was a pleasure of doing this, and we'll do another one in a couple of days for countries on the other side of the world. But we hope that this has been able to clarify what the IP system can do also for the particular situation of public research in agriculture for development. So with that, from our side, I think, thank you very much.
Thank you for the opportunity.